Good morning. I would like to share to you the legal procedures on how due process is done for every cases, administrative or criminal. Let's take a look first the Department of Education Order number 49 series 2000 with regard to revised rules of procedure of the Department of Education in administrative cases. Legally, administrative cases are tantamount to criminal case. Criminal cases, I mean. But criminal cases are not equated as administrative in nature. In other words, if you are already charged to administrative, automatically you have a criminal liability according to legal experts and Supreme Court decisions previously done. There are grounds for disciplinary action or administrative in nature and criminal liability. First, dishonesty. What are the forms or, manifestation of dishonesty? Number one is, changing grades as superiors. You are very abusive to love with the student's grade. Number two, oppression, neglect of duty, misconduct, partnered with dishonesty, disgraceful and immoral conduct, being notoriously undesirable, discourtesy in the course of official duties, inefficiency and incompetence in the performance of official duties, receiving for personal use of a fee, gift, or other valuable thing in the course of official duties or in connection therewith when such fee, gift, or other valuable thing is given by any person in the hope or expectation of receiving a favor or better treatment than that accorded other persons or committing acts punishable under the anti-graft laws. Conviction of a crime involving moral turpitude, improper or unauthorized solicitation of contributions from subordinate employees and by teachers or school officials from school children, violation of existing civil service law and rules or reasonable office or regulations, falsification of official documents, frequent unauthorized absences or tardiness in reporting for duty, loafing or frequent unauthorized absences from duty during regular office hours, habitual drunkenness, grumbling prohibited by law, refusal to perform official duty or render overtime service, disgraceful, immoral, or dishonest conduct prior to entering the service, physical or mental incapacity or disability due to immoral, vicious habits, borrowing money by superior officers from subordinates or lending by subordinates to superior officers, lending money at usurious rates of interest, willful failure to pay just debts or willful failure to pay taxes due the government, contracting loans of money or other property from persons with whom the office of the employee is concerned as business relations, pursuit of private business, vocation or profession without the permission required by the civil service rules and regulations, insubordination, engaging directly or indirectly in partisan political activities, by one holding a non-political office, conduct prejudicial to the best interests of the service, lobbying for personal interest or gain in legislative halls or offices without authority, promoting the sale of tickets in behalf of private enterprises that are not intended for charitable or public welfare purposes, and even in the further cases, if there is no prior authority, nepotism as defined in Section 59, Chapter 8, Subtitle A, Title 1, Book 5 of EO number 292, sexual harassment as defined and penalized under CSC Resolution number 1010940. Now, what is the remedy for this or immediate action made by the department? Number one is preventive suspension, especially if the suspect is higher than the complainant. When you say preventive suspension, that is upon the motion of the complainant or motu proprio, the proper disciplinary authority may issue an order of preventive suspension upon issuance of the formal charge immediately thereafter to any subordinate officer or employee under his authority pending an investigation if the charges involve, number one, dishonesty, oppression, grave misconduct, neglect in the performance of duty, or if there are reasons to believe that the respondent is guilty of charges which would warrant his removal from the service. You see, they could issue preventive suspension if you are dishonest, oppressor, serious misconduct, defined as defined by labor code and this order from Department of Education. There are many legal impediments made by the, superior. Then the action, reason for preventive suspension. An order of preventive suspension may also be issued by the disciplining authority to temporarily remove the respondent from the scene of his misfeasance or malfeasance and to preclude the possibility of exerting undue influence or pressure on the witnesses against him or tampering of documentary evidence on file with his office. Imagine. So, if you are official of a certain organization, be careful. You're not supposed to, to show that you are already on top of that organization and that they can charge us, abuse of authority, something like that, dishonesty, you know, falsification of public documents, perjury, unbecoming, and there are many other grounds for termination. Good luck to all administrators. Even if you are already the Secretary of Education, under secretaries, assistant secretaries, and all other officials, you're not supposed to use your position to coerce or to make criminally action or, may paglalagyan ka, may lugar ka sa batas, sa ngalan ng batas. Sabi nga ni Lino, nobody is above the law. Okay? Good luck.